After a man died despite cancer treatment, his widow accused the doctor of not revealing the truth about his imminent and inevitable demise. This resulted in the informed consent case, Arato versus Avedon. Miklos Arato was only 42 when he was diagnosed with pancreatic cancer. At the oncologist's office, Arato filled out a questionnaire in which he indicated that he wished to be told the truth about his condition, as opposed to having the physician, quote, bear the burden, unquote, for him. The physicians, including Melvin Avedon, told Arato that he was at serious risk of recurrence, and if this happened, his condition would be incurable. However, an experimental treatment involving chemotherapy plus radiation had shown some promise in treating pancreatic cancer, and they thought Arato was a good candidate. At no point did the doctors disclose to Arato that pancreatic cancer generally has an extremely high mortality rate or inform him of his statistical life expectancy. Arato chose to proceed with chemo and radiation. His cancer returned after a few months, and he died a year after the initial diagnosis. Arato's wife and children sued the doctors. They alleged that the doctors had failed to explain that pancreatic cancer is practically incurable and that only 5 to 10% of patients survive for 5 years. Without this information, he couldn't give informed consent to treatment. They argued that because Arato had undergone treatment based on a false hope of a cure, he'd failed to put his affairs in order, leading to the failure of his business and significant financial losses. The trial jury found for the doctors. The Court of Appeal held that the doctors had breached the duty to disclose information that would be material to Arato's decision to undergo treatment. It reversed and ordered a new trial. The California Supreme Court granted cert.